turn my attention to McGirt, a decision that was made by the Supreme Court that's really put law enforcement and law and order at a heavy strain, and it's unique to Oklahoma. But it's caused a lot of problems. We are greatly under-resourced. I would compare some areas to literally the Wild West. We have law enforcement that can't pull over individuals with tribal tags. We have tribes that are suing, that are literally suing the municipalities to which they govern in. And
Hey there, everybody. That is Oklahoma Senator Markwayne Mullen, who is also an enrolled member of the Cherokee Nation. He is providing his comments on the McGirt decision. Most of us in Indian country know that the McGirt decision was a landmark Indian law case that was handed down by the Supreme Court in 2020, which ruled that the Muskogee Creek Nation's reservation had never been disestablished. Shortly thereafter, there were several other Indian tribes like the Choctaw, Chickasaw, Cherokee, and also the Seminole and a few other Indian tribes in eastern Oklahoma that had declared that their reservations had also never been disestablished. So now a good part of eastern Oklahoma is now considered reservation land. So Markwayne Mullen is expressing his concern over the issues that this has caused in Oklahoma, saying that it's caused disruption. He compared it to the Wild Wild West, saying that local law enforcement don't feel like they can pull over cars with tribal tags, really just painting this entire worst case scenario in Oklahoma than was actually happening here on the ground. I live in Oklahoma. I know better. We know that all the tribes, like the 5 tribes, have all put in millions of dollars ever since their reservations have been declared to not have been disestablished so that they can provide the law enforcement that's necessary. But anyway, we expect this. It's almost like he's mimicking the same thing that the current governor for Oklahoma, Kevin Stitt, has been trying to do. He's trying to paint a worst case scenario, making it sound like there's no law enforcement going on in those areas, making it sound like it's the Wild Wild West. Almost like you're trying to plead to Congress to say, hey, can you guys declare that these reservations have been disestablished? But the Supreme Court made their ruling, and we all know that only Congress, through their plenary power, can disestablish a reservation. And Congress has not done so. Markwayne Mullen is a senator. If he feels like that's what needs to be done, he could simply submit something as a senator to try to get that law passed. However, it would not make Cherokee Nation happy. It would not make Choctaw, Chickasaw, Creek, Seminole. It would not make any of those tribes happy because he works for them, right? He's a U.S. senator. He covers the whole state. And it doesn't matter whether you're native or non-native. He's a senator, and we're all his constituents. So you have to look at the entire picture and stuff like that. But I want to digress a little bit because the picture that Markwayne Mullen is painting is far from the truth. But let's go back to the root of the issue. And I always bring this up whenever I have an opportunity to speak because the United States court system are the ones that started this whole jurisdiction issue that has caused these public safety concerns, not only amongst Native American tribes on their reservations, but also with the state and local counties and municipalities as well. Because in 1978, the Supreme Court ruled in a case, Oliphant versus Suquamish tribe, that the tribe did not have the power or authority to prosecute a non-native that committed a crime on their reservation. Mark David Oliphant assaulted and resisted arrest of a tribal police officer on the Suquamish reservation. He filed a writ of habeas corpus arguing that the tribe did not have jurisdiction over him to prosecute him. The Western District of Washington disagreed with Mark Oliphant. It goes to the Ninth Circuit. The Ninth Circuit upholds the lower court's decision and says that no, the tribe does have jurisdiction over you, Mark Oliphant, to arrest you and prosecute you. His attorney files a certiorari to the Supreme Court. Unfortunately, they take it, and unfortunately, they overruled the Ninth Circuit and the lower court, claiming that the tribe has no jurisdiction to arrest and prosecute Mark Oliphant, even though he assaulted a tribal police officer and he resisted arrest. And from there have been public safety issues ever since. Why? Because the ruling did not leave a pathway for how tribes would then handle crime by non-Indians on their reservation, which resulted, in my opinion, in a lot of the MMIP cases that we have ongoing right now in Indian country, missing and murdered indigenous people. When you tell the world of non-Indians that, hey, these Indians, they can't arrest you, they can't prosecute you, they don't have jurisdiction, what do you think non-Indians are going to do? They're going to go to the reservations and try to commit their crimes and then turn around and holler, hey, they don't have jurisdiction over me, they can't prosecute me, they can't arrest me. And that's exactly what happened for decades. It was only until recently, around 2010, 2013, that Congress passed VAWA, the Violence Against Women's Act, that gave some tribes some limited authority and power to actually arrest and prosecute non-Indians that committed crimes or violence against women on the reservations. But not all tribes actually have to qualify for it. So the issue lies in our courts with the ruling in Oliphant, and our issues lie with the Congress, who could come up with an Oliphant fix, possibly, right? If they chose to do so. But just like the carcerity fix regarding the gaming issue, Congress has failed to act on it. So I don't like it whenever senators like Markwayne Mullen or governors like Kevin Stitt get up there and they make it sound like it's all the Indians' fault. Like, oh my God, why are we allowing two different set of laws for two different races? Because your court system's the one that established that. 1978, Oliphant versus Suquamish tribe, right? And as far as what Markwayne Mullen said, where local law enforcement can't pull over, they can pull them over. The issue is who has the right to prosecute those individuals. So local law enforcement can pull a tribal tag over if they're speeding, if they committed a crime. They can cite them, they can probably even arrest them, but then they just have to turn around and allow the local tribal jurisdiction to prosecute them, right? And thanks to another ruling, thankfully from the Supreme Court, tribal law enforcement can do the same thing. They can pull over a non-Indian and hold them and allow local law enforcement to go ahead and take over the case from there. It doesn't mean that you just let them drive around like the Wild Wild West, like Markwayne Mullen's saying, or like Kevin Stitt has tried to portray in the past. But anyway, Congress, if you want to come up with a fix, come up with something that works for everybody, okay? The court system is the one that created these jurisdictional issues. Congress has an opportunity to fix it, all right? If you like what you hear and see, give me a like and follow. Please like and share. Appreciate all y'all that continue to follow me, all right? Ha-ho.